Hi, I'm Dr. Angie White, Director of Instructional Technology for Oldham County Schools, and I have some important information regarding student privacy and data sharing that I need to discuss with you today. So, first of all, you might be wondering, what does data sharing have to do with me and student privacy? We need to make sure that all users understand and know the federal and state legislation, current district policy, and the processes that we have for vetting and monitoring websites with logins, software, and apps. So, first, let's look at federal and state legislation and our district policy. At the federal level, we have FERPA from 1974, and that's the Family Educational Rights and Privacy Act. We also have COPA from 1998, and that's the Children's Online Privacy Protection Act. And SIPA from 2000, and that's the Children's Internet Protection Act. At the state level, we have House Bill 232, which was signed into law on April 10th, 2014. And at the district level, we have our staff acceptable use policy and our student acceptable use policy. So, to dig a little bit deeper, what exactly is FERPA? And it is a federal law that protects the privacy of student education records. COPA is targeted at operators of websites and online services where their services are directed to children under 13 years of age. And these operators of websites and online services that have actual knowledge that they're collecting personal information from children under the age of 13. And if that is the case, they have to do each of the following. They have to post online privacy policies regarding personal information that's collected from these children under the age of 13. They have to provide direct notice to parents regarding the collection, use, and disclosure of personal information for children under the age of 13. They are to obtain verifiable parental consent prior to any collection, use, and or disclosure of that personal information from children under the age of 13. They provide a means for parents to review personal information that's collected from their child. They are to establish and maintain reasonable procedures to protect personal information collected from children under the age of 13. And they are to retain personal information collected online from a child for only as long as is necessary and delete the information using reasonable measures to protect against its unauthorized access or use. So, what is SIPA? Schools are required to adopt and implement an internet safety policy addressing the following: access by minors to inappropriate manner on the internet, the safety and security of minors when using electronic mail, chat rooms, or other forms of electronic communications, unauthorized access, including hacking and other unlawful activities by minors online, unauthorized disclosure, use, and dissemination of personal information regarding minors, and measures restricting minors' access to materials harmful to them. Then we have House Bill 232, or KRS 365.734. That KRS prohibits certain uses of student data by cloud vendors. It defines student data, and it requires cloud providers to certify in writing that they comply with the KRS. So, what exactly is student data? According to this KRS, and student data means any information or material in any medium or format that concerns a student and is created or provided by the student in the course of the student's use of cloud computing services or an agent or employee of the educational institution in connection with the cloud computing services. Student data includes the student's name, email address, email messages, postal address, phone number, and any documents, photos, or unique identifiers relating to the student. So, how can student data be used? According to the KRS, it prohibits cloud providers from processing student data for any purpose other than providing its services. Specifically, it prohibits the use of data for advertising or facilitating advertising, and it prohibits selling, disclosing, or otherwise processing student data for any commercial purpose. At the district level, we have a staff acceptable use policy and a student acceptable use policy. So let's first review the staff acceptable use policy. I'm showing you here page 2 of 3, and it's under section 4, usage rules, and under B, network and internet rules for employees. And the ones that are relevant here for this discussion have been highlighted. So, number 15, the employee shall not transmit personally identifying information regarding a student via email or the internet. Number 16, the employee shall not use any email service other than the district mail system. Number 18, the school will keep on file a copy of all executed software licenses or original documentation of software purchased by the school. Number 19, employees shall not install or repair any software or hardware on individual workstations without consultation and assistance from the Site Technology Coordinator, or STC. Number 21, the employee will not transmit a student's personally identifiable information, so that includes written work, pictures, web postings, etc., without a parent's written consent. Then we have the Oldham County Student Acceptable Use Policy. The portion that I have here is what's relevant to us in this discussion. The Oldham County Board of Education supports the use of varied technology as instructional tools and expects every student to demonstrate skills in the use of technology as outlined in the District Technology Exit Standards. As part of our commitment to support student learning opportunities focusing on communication, critical thinking and problem solving, collaboration, and creativity, Oldham County Schools provides all students with a variety of digital learning tools, including G Suite for Education, core, and additional services. These learning tools are carefully selected for their educational value and compatibility with the Oldham County Schools curriculum to support and enhance learning. Some digital tools require that the Oldham County Schools share limited personal information, such as the student's name and email address, for the purpose of creating an account to use the tool or service. Personal information, name and email address, is used and shared by the Oldham County Schools for the above noted purposes under the Children's Online Privacy Protection Act. Please find a list of district-provided digital learning tools that are available to all students and teachers at the following link. So let's look at that review process and how we came up with that approved list. Kentucky law requires districts have procedures in place that ensure the privacy and security of student personally identifiable information, or PII, that's stored in internet-enabled services or cloud services, and to ensure that those cloud-based services themselves have their own privacy and security policies, and they do not sell student information for use by others. The district must annually read the terms of service and privacy policies for every cloud-based service that the district utilizes that collects PII or is used by students under the age of 13. We have a living spreadsheet in our district with information regarding the websites with logins, software, and apps that we use. I need for you to look over the list and note whether or not you or your school are using any of those services. And if you are using any of the services, you need to take note whether it's okay to use without condition, or if it's okay to use the service with some conditions. If you're using any website requiring login software or an app that is not on the spreadsheet, we're going to go through that process in the next slide, but it's important that it is on the sheet and that you go through that vetting software. So let's look at this living spreadsheet. And it's color-coded. Blue items are purchased by the district, and our board attorney has reviewed them, and they are approved for use by our students. Orange means we're waiting for board approval, and at this point, it cannot be used. Green is simply that it's approved without any conditions. Yellow means that it's approved with conditions or restrictions. And red means that it's not approved. So let's look at these. As you scroll through, you'll find that they're in alphabetical order, so you can easily find them. Sometimes it's the name of the software. If it's a larger company, it may be under the company's name. So let's look first at Accessible Literacy Learning. This is a piece of software and it's approved. This line is in green. We also, as you scroll over, can see where the terms of use were last updated and when they were last checked. If we scroll down a little, and let's look at Animoto, the educational version, that's an app. It's approved with conditions. You must be 13 years or older to use this, or if it's used by anyone under 13, it has to be set up under a teacher's Education Edmodo account. Here's another with Arduino. It's a piece of software and it's approved with restrictions. So you have to use teacher assigned accounts here for under 16. And Artsonia is free, but once again, it's approved with restrictions. You must have express parental consent for under 13. So what this means is that just having the parent sign off on the AUP as a part of their online registration is not sufficient. You have to have a separate parental consent, and the teacher and or school are responsible for getting that. So not only is it important that you check to make sure that what you're using is on this list, but also what the conditions are that you can use that. And then we also need to be diligent in checking the dates of those terms of use to make sure that nothing has changed. As I mentioned, if you find something that you're using or your school is using that is not on that list, then this is the process that we go through in our district to make sure that we are in compliance with the federal, state, and our district policies. So if we start in the upper left-hand corner with the website that requires a login, the software, or the app, there's two things that we have to determine. Is this a free item or is this paid? If it's paid, we have to move to the next step, where a principal sends the quote or a contract with the privacy policy and the terms of use link for board approval. The board attorney then reviews that quote or contract and the privacy policy and the terms of use, and will either approve it or indicate any revisions. If it needs revision, the board attorney will indicate that, and the school secures that revised contract. It is not the district's responsibility, it is the school's responsibility to get that revised contract. An example would be indemnity. Many times the contracts expect the school district to self-indemnify. We cannot do that. So that clause has to be removed, and it's the responsibility of the school to secure that contract without the clause. So once we have that revised contract or the board attorney approves, then it goes to the next step, which is the first step if it's a free piece of software or a website with a login that's free or an app. So we have the requester submits a service ticket for review. So whoever is wanting to use this specific website with a login or software or app, they just submit a work order ticket, and at that point it's sent to me for review. I review it and enter it on the spreadsheet that we looked at. I, based on what I find out about that piece of software, approve it with conditions, approve it with restrictions, or it's not approved. Once I've entered that on the spreadsheet, it then is populated onto the website that you saw for the student AUP. This is how we make sure that we have parental consent for those items that require parental consent for under 13 or under 16, whatever the issue may be. So it's very important that we make sure that all of these are on that list, and going through this process ensures that. If you have any questions, please direct those to your STC. If your STC is not able to answer that for you, they can contact me, and I will get them an answer. And just make sure that you're completing this process so that we can make sure that we're keeping our students safe and that we're abiding by federal, state, and our district policy.